Welcome to our webinar series, Enhancing Court Access for Domestic Violence Survivors from Diverse Communities. My name is Ayana Wallace, and I'm the Training and Technical Assistance Manager with Ujima Inc. Ujima Inc. is the National Center on Violence Against Women in the Black community, one of few nationally designated culturally specific resource centers. Our work is aimed at centering the realities of Black women and girls and of survivors within the Black community, which we do through policy and legislation, outreach and technical assistance, training, and our research and evaluation team. We are excited for you to be with us today, and I now have the pleasure of turning things over to Nida Abbasi. Nida, take it away.
Hi, everyone. I'm Nida Abbasi from the Center for Court Innovation. I work primarily on issues related to court responses to domestic violence, including domestic violence dynamics, accessibility, and culturally responsive practices.
Hi, everyone. My name is Rosa Figueroa. I am a retired judge, recently retired judge from the 11th Judicial Circuit in and for Miami-Dade County. And I was on the bench for a little bit over 20 years. The bulk of my work was dealing with families afflicted with domestic violence, dependency, which is child welfare, and the interrelated commonality of those issues, and the Unified Family Court, where we dealt with juvenile delinquency, dependency, and family court issues along with domestic violence. I'm happy to be here.
So by the end of today's session, we're hoping all the participants will be able to identify barriers and challenges to accessing justice that survivors from diverse communities may face in court and justice systems, identify solutions and design strategies for reducing barriers based on promising practices rooted in promoting procedural fairness or procedural justice, facilitate greater access to justice by fostering more culturally responsive practices in courts, and finally, develop action plans and access additional resources and technical assistance in order to facilitate increased access to safety and justice in gender-based violence cases.
So when we talk about court culture and access to justice and bias, a lot can come up for folks. So let's actually take a step back for a second. When we define culture generally, we typically define culture as a body of beliefs, ideas, and ideals used for cohesion and conformity. In other words, culture can really be thought of as not only the ties that bind folk together, but also as the blueprint for the ways in which folks operate in society, within our individual communities, and even dictates our social norms. When we talk about culture, we really have to also think about the ways in which culture shapes how folks engage with one another in different spaces, and how culture informs the roles that people play in relationships, families, and in our workplaces. When we talk about bias, it's of course important to be able to define it and recognize it when it presents, especially as it relates to implicit bias and the unintentional impacts that implicit biases can have on survivors and on the cultures of our workplace. Bias is a tendency, inclination, or prejudice toward or against something or someone. Biases are often based in stereotypes rather than actual knowledge or extensive experience of an individual or circumstance. And remember, stereotypes are widely held, but fixed and oversimplified images or ideas of a particular type of person, group, or thing. So the fact that so much bias is based in oversimplified images of people, groups, or places can really be problematic, because those ideas, those images, those perceptions will inevitably influence how we view or even how we respond to individuals who navigate our systems. And when it comes to access to justice, what justice even means to folks can really vary. For certain individuals, justice means that their abusive partner will serve jail time. For others, it means that their partner will be ordered to leave the home and cannot contact them any longer. And for others still, it means engaging in restorative practices and not engaging in the criminal legal system at all. So to understand that for each of us potentially, justice can mean something different really helps us better respond to survivors' needs. Okay, so what then is court culture? Well, knowing what you know about culture generally, I think that question is actually up to you all to define and to answer. What is your specific court culture? Are folks very welcoming and responsive? Do folks respond in a trauma-informed way? What types of community engagement strategies do you all employ? How are the dynamics between folks that actually work together in space together? Are certain courtrooms more relaxed than others? Do survivors feel hurt? All of these questions you can really start to ask yourself as you're defining and really exploring what your court culture looks like. Again, if culture is a body of beliefs, ideas, and ideals used for cohesion and conformity, the blueprint for the ways in which folks operate and the guidelines to our social norms, how are folks then showing up in the workplace? And as you're defining your own court culture, it's important to identify common values and furthermore, how you all plan to enact or fulfill those values. Efficiency in court management is a great value to uphold. We want our court processes flowing well. We want people to be able to navigate around the courtroom and around the courthouse. We want paperwork and documentation to be streamlined and processed properly, right? And still, we want to make sure that we don't get so caught up in court management and processes that we lose perspective on survivor needs and when practices and policies may need to change. Bias versus neutrality. And I'm really going to focus in here on bias because Judge Figueroa is going to give us a great breakdown on neutrality in just a bit. I really appreciate the opportunity to reflect on and define bias, but let's think more about how bias, and in particular, implicit bias, may present and the impact it can have on a survivor. Think about this scenario. We have a survivor who's fled their home and gone to a DV shelter with their child in tow after an incredibly violent incident with their partner. They're working with DV advocates, making safety plans, doing very well. Because their husband can't locate them, they file a missing persons report and report that the survivor is mentally and emotionally unstable. We have a survivor that's fled her home and gone to a DV shelter with her child in tow. She's working with DV advocates, making safety plans, doing very well. But because her husband can't locate her, he then files a missing persons report and reports to the police that she is mentally unstable. He then has her emergency petitioned, goes to court, and obtains emergency child custody. Unbeknownst to many, the husband's main tool of abuse is manipulating the court system. He's a charismatic abuser who uses his many privileges and also the implicit bias that folks have around mental health to his advantage against the survivor. He's wealthy, highly educated, well-spoken, and attractive, no documented mental health history, no criminal background history. The husband then continues his sustained attack by filing protective orders and false violation claims, by constantly modifying the child custody agreement, and even continues to have the survivor emergency petitioned over the course of her stay in shelter. Does this sound like it can happen? Where potentially does bias lie? Even implicit bias, where can that be found? And to be clear, things like this happen to survivors all the time. So really making sure to be tuned into bias is essential. Similarly, I've worked with survivors who have come back from court and said things to me like, I felt like they were harder on me for being 5 minutes late than they were on my partner for violating the order. A notion that ties right back into some of our other values like court efficiency and offender accountability. Victim safety is something to really pay attention to as well, of course, inside of an actual court building, but also when thinking about the design of your court processes. There are many different layers to victim safety, and victim safety can mean a lot of different things for different people. But we want to make sure that we're centering victim safety, not only through the actual rulings that a survivor might get in their case, but through things like staffing enough courthouse security and bailiffs, by ensuring that there are cameras and adequate lighting in parking lots and parking garages, by enforcing and distinguishing departure times so that the survivor and the perpetrator or the harm doer aren't literally walking down the hallway together. When considering the weight of precedent, the questions that I ask myself are, what does the weight of precedent mean to the status quo? And are folks so focused on how things used to be, that we're no longer responding efficiently and as effectively and holistically as we could. There are many different questions you can ask, but when we think about weight of precedent, let's make sure that we're really investigating, acknowledging, and truly understanding what happens to and with survivors who navigate our system. Being paper-driven. So being paper-driven in and of itself is not an issue. I think for me, the issue really comes when other factors aren't taken into consideration as well. For instance, when a court system is too paper-driven, the process can become convoluted, inaccessible, whether that be based on technology needs or linguist access needs, or the process can actually become traumatic for a survivor. Questions then to ask yourselves: are survivors able to easily understand the questions that are being asked on intake forms? Are survivors feeling that their voices are still being centered and that they're able to tell their full stories? And is a survivor even able to fill out this massive stack of forms after an attack or after an incident? And then we have offender accountability. Offender accountability can actually be thought of really as a necessity to our court system, right? Because without it, survivors in our communities will continue to experience harm or even violence. It is important, I do want to make this disclaimer or this announcement, to remember when we're thinking about offender accountability in the context of domestic violence, sexual violence, and intimate partner stalking dynamics, even when the survivor may appear to be the agitator or may appear to be the perpetrator in this specific incident, it's still essential to take into consideration the totality of the intimate partner relationship and who is the actual predominant aggressor in the relationship. So now let's take a deeper look into the concept of neutrality with a word from Judge Figueroa.
So what is neutrality? When I've talked to my colleagues on the bench as to what is neutrality, we often get the most common answers we get are, well, I don't take sides. I don't participate in the litigation before me. I don't like to get involved. I'm just being fair. I call the strikes and the balls as I see it. I don't get involved and I treat everyone the same. What I'd like to propose and what I'd like to ask is, what does neutrality mean to our system of jurisprudence? What's the big deal about the neutrality? And in order to delve into the subject, I'm inviting you to take a deeper view of what neutrality means to the judicial system in the context of access to justice when addressing the complexity of issues plaguing families afflicted by domestic violence. Fair and impartial courts are the guarantors of equal justice in our American constitutional democracy. The very legitimacy of the courts depends on the public's perception that the judges will treat everyone fairly and without bias, and that any party, regardless of their wealth or connections, is going to have a fair day in court. I think we can all agree that that's really one of the bedrocks of our system of jurisprudence in the United States. In an interview with Bill Moyer in 1999, Justice Kennedy gave a very eloquent definition of what neutrality was and what the judge's role in being a neutral arbiter of the facts was, which I'd like to share with you. And what Justice Kennedy says in that interview is that our system presumes that there are certain principles that are more important than the temper of our times. And you must have a judge who is detached, who is independent, who is fair, who is committed only to those principles and not to public pressures of other sorts. And that that's the meaning of neutrality. He went on to stress that it was serious because the law commands allegiance if it commands respect, and respect only if the public thinks that the judges are fair. In the same interview, Justice Breyer goes on to say, independence isn't doing whatever you want. Independence means that you decide according to the facts and applying the laws to those facts. So what does this mean when we talk about access to justice in the context of domestic violence? And if we accept Justice Kennedy and Justice Breyer's definition of neutrality and judicial independence, we proceed with the premise that our court system, and thus the culture in the courtroom, should be designed in a manner that is conducive to a fair and a deliberate exposition of the facts presented by the case at bar so that the judicial officer can apply the law and render a fair decision for both sides that promotes the safety and well-being of not only the litigants, but of all the family members involved. We opened our session by talking about culture in the courtroom, and I would suggest that the culture has a great impact on the ability to know what the facts are so that a fair and neutral court decision can be made on the case based upon the applicable law. Now, court's culture is inherently impacted by the particular community it serves and by the types of cases it serves. For example, a court culture in a domestic violence or child abuse case in my home city of Miami, which is a very urbanized city with a multicultural population that speaks several different languages or derivatives of those languages, is going to be much different than a court dealing with the same issues in the suburbs of New Jersey, Arizona, or Nebraska that might be more or less homogeneous, more or less rural, and will have different regional histories, geographical makeups, and preferences. Certainly, there are going to be possible language barriers as well as beliefs cemented in a litigant based upon the country of origin and why that person immigrated to the United States that are going to have an effect on the trier of fact obtaining a neutral and fair decision that is going to be affected in Miami in a way that's different in other parts of the country, such as New Jersey or Nebraska. And if the population needing access to the justice is a population with low English proficiency or with a disability that inhibits communication in a widely common manner, how are you going to get to the facts in that case so that you can apply the law in a fair and justice manner? Equally important would it be how would the proficiency of an interpreter, who the interpreter is, have an effect on the litigant's ability to communicate and tell you the facts? So how will cultural views affect the litigant's ability to expose the facts of their position? If there is a culture of distrust of the judicial system, either due to the litigant's history, historical trauma, the litigant's experience with the judicial system of his or her country of origin, immigration concerns, or past experiences, how will the court's demeanor affect the litigant's ability to state the facts so that the judicial officer can remain neutral and impose a fair and judicious decision? These are all considerations that have an impact on the ability to be neutral because they have an ability to impact the manner in which you get a true and fair exposition of the facts so that the law can be applied. And these considerations are going to be different depending on the nature of the litigants before us. And we will delve into all the other issues that are going to deal with court culture. These are issues that affect our ability to reach our aspiration of a fair and neutral court system. In order to apply the law to the facts in a neutral, unbiased way, you must be aware of these issues and aware of their impact on the ability to determine what the facts are so that you can make the best decision possible by creating an environment that fosters the truth. Because what's the end result? What is the goal of the judicial system and of the judicial officer? In over 20 years on the bench, I never heard a colleague say that he or she didn't really care about what the outcome of a decision was. It's usually the decision where you didn't really understand the facts or where there was something haunting you about your ability to really gauge the dynamics of a relationship or where something horribly went wrong that you question, did I know the facts? Did I get a fair picture? Did I really understand what was happening to this family? And could I have made a better decision? And why do we do that? Because generally, if we are involved in this type of work of dealing with families afflicted with violence, we want to make a difference. What's the end game? We want safety for a child. We want safety for a survivor. We want safety for the family. And we also want safety and a betterment for the person who's committing the violence. Does being culturally responsive mean that the court is biased? Or does it mean that it is neutral because it fosters an environment that allows the truth to come out so that the law can be applied to the facts, the real facts? Can the court be culturally responsive in a domestic violence case or a case involving violence and still remain neutral? My response, and what I would suggest to all of you, is that it is a resounding Yes. Courts are to resolve disputes fairly, to evaluate the truth, to adjudicate the issues. To be fair, you must allow equal access to everyone, regardless of their individuality. We as judicial officers come with different experiences and cultural preconceived notions. Is there anything wrong with belonging to a privileged class or a class that enjoys certain privileges? The answer to that is a resounding no, and there's no apology that's required as a result of enjoying certain privileges. I'm a Cuban American. I believe that makes me a privileged class. Why? Because as a Cuban American, my family enjoyed preferential immigration status when we came to the United States that was not open to other Hispanic immigrants. We never faced the fear of instability of deportation, and INS or any form of government entity was never seen as a threat or something that could separate me or anyone that I loved from other members of the family. I now live in a community that predominantly shares my cultural experience. I live in Miami as a Cuban American, you can imagine. Because of my parents' educational background and their ability to thrive, I was able to access many of the blessings afforded by the American dream in a way that other members of the Hispanic community have not been able to or have experienced more difficulty doing so. My family's experience may have not always been easy, but it was certainly not plagued by some of the issues facing other immigrant families, and that makes me privileged. I don't feel I have to apologize for the privilege I enjoyed, nor do I believe that being culturally responsive requires apology for anyone else's privilege. Having an education, speaking the language is a privilege. But the whole point of addressing inherent bias and privilege and attempting to create a courtroom responsive is not to judge privilege, but it is to bring it to the forefront so that we can be conscious of how it might impact our ability to create a system that lets the truth of the issues afflicting a family come to the forefront so that the law can be applied to the facts. Litigants are multidimensional, different needs, different circumstances, different beliefs. Asian Americans are going to be different than Hispanics, than African Americans, than American Indians. The list goes on. The difficulty of the courtroom experience and everything it entails is augmented by previous trauma, language, economic barriers. The failure to recognize these differences can lead to resolutions that bias some types of litigants over others, ignores the truth of the issues being presented, renders unjust results that can re-victimize those the system seeks to protect and the ones that we want to serve and make a difference for. Recognizing these differences and creating a culture in which the issues affecting the family can be addressed fairly, with the truth of the facts afflicting the family openly exposed in order to promote safety and healing needed, is a way to ensure the neutral disposition of the issues at bar are achieved without preconceived notions or bias. Therefore, you need to create an atmosphere where you can cultivate the exposition of the truth. Paves the way for healing of not only the victim and children, but the person who committed the violence as well. Without an honest and fair exposition of the true nature of the factors bringing the case to court, there is no accountability and there is no neutrality. Without accountability, there's no possibility of redemption and growth. So I like to finish this short display with a cartoon that shows a couple in an accident, if we can go to that. And you can see that the couple's saying, well, I don't like to pick sides. We're not here to choose sides, but we are here to make sure that there's no car accident and that we try to make the best decision possible to ensure safety for the families that we serve.
So why does understanding court culture and bias matter in the courtroom?
Nida, I know that you're about to give us a really thorough breakdown, but for me, the short answer to this question is that understanding court culture and bias allows us to be more responsive to the needs of survivors. It allows us to be and to create safer spaces and safer communities, and ultimately impacts the survivor's perception of justice and their experience in both accessing justice and resources.
Let's talk about how the concept of access to justice fits into court culture. Access to justice is a broad term that essentially describes how any individual should be granted access in the court. and the justice system, regardless of their circumstances. So whether they have limited English proficiency, they don't have access to transportation, if they're living with a disability, no matter what the situation, the court itself should be structured to facilitate access, such as through interpreters and translated materials, through public transportation, through ramps and elevators and educated staff. And court culture should promote the significance of accessibility. So another aspect of access and court culture involves the concept of procedural fairness. This describes the way that litigants perceive the court process and how they were treated, especially whether it felt fair and impartial. So procedural fairness is a perception that you're being treated with respect and your concerns are being taken seriously. And it's especially significant in domestic violence cases, as the way fairness is perceived can impact a survivor's willingness to view court as a resource and impact whether they come back to court. And the person who causes harm, it can impact their willingness to comply with orders. Individuals coming into the court on a domestic violence case are often, if not always, experiencing trauma. And there's a lot of things about that process that can make the trauma worse or can just leave them feeling more confused, frustrated, and helpless. So that's where procedural fairness can come into help. Procedural fairness tries to enhance the court process for litigants by emphasizing these four key principles: voice, respect, neutrality, and understanding. So voice means that the litigant felt like they had an opportunity to tell their story, to be heard by the court. Respect involves the litigants feeling like they were treated with dignity and respect by everyone in the court, including the judges, the attorneys, and court staff. So neutrality is when litigants perceive that the decision-making process is unbiased and trustworthy. And finally, understanding refers to litigants understanding and knowing their rights and the case process and what is expected of them in order to go through with the case and comply with court orders. So because of these factors, procedural fairness can increase public confidence in the justice system, improve respect for and compliance with court orders, and encourage individuals to keep using the court system, which is especially important in domestic violence cases in order to facilitate greater access to the courthouse and also promote people being able to access and being able to easily comply with court orders because they understand what they mean and they feel like they had a fair opportunity throughout the court process. However, it is important to note that perceived fairness does not replace actually ensuring that the court process is fair and unbiased and neutral towards both parties. So while procedural fairness can improve the way the public feels towards the court process because they had, a positive or good experience when they entered the courthouse, it is more important for the decision-making process in all cases, including domestic violence cases, to be equitable towards the parties. So how do we start building a more just culture? This is a resource developed by our colleague, Purvi Shah, that you and others at your site can use to start thinking about ways to enhance your court culture and reduce bias in the courthouse. So we recommend that you do the worksheet individually first and then with your team. You'll start off by reflecting how you describe your court's culture. What is it like generally for people who work there and people coming in on domestic violence cases? So just think about that for a little while before jotting down some ideas. Then you'll get into specific details. Think about who your court culture works for, which groups of people and why, and who does it not work for and why? Who's being left out? Who's not even coming to court? These questions are intentionally broad, so think about as many different types of groups of people as you can. And then finally, you'll move on to action planning. So what strategies can you and your staff use to reduce bias in the courthouse and enable dignity for the groups that you listed in the second column above? So you want to identify at least 3 to 4 of the groups, and what strategy you would use and what the impact would be. So for example, if you identified individuals who are LGBTQ as not accessing the court and not accessing other services for domestic violence, a potential strategy could be reaching out to local service providers who work with LGBTQ survivors and trying to begin a dialogue with them. If there aren't any local service providers, another option would be contacting a national organization who specializes in that field. So you really want to think about what is present in your community and how you can leverage some of those local resources first, before moving on to other resources as well, and just start to map out some of the strategies you can use to address any gaps in your system.